Hey chat, it's your boy Jacob. Today we're back again. This time going over what should be part 5, the motion to dismiss from the City of Albert Lea City Council in the mandamus issue. There's not much to say here other than this seems to be hanging on one solitary reason, I'll put it that way, purely on whether or not the judge has or does not have jurisdiction over this matter. I'm not shocked. This was completely expected on our end. Like I said in the previous video, a lawyer can't really facilitate their client breaking the law. So sometimes the only thing you can do is attempt to motion to dismiss and hope for the best. Let's just dive in here. Here's the memorandum of law in support of motion to dismiss. The actual kind of motion, not the memorandum itself, is like one single paragraph. It is very short. Maybe I should show that to you as well. I don't know, but let's dig in here. Introduction. This case concerns plaintiffs / petitioners Jacob and my business. We are requesting the court compel the City of Albert Lea to issue my cannabis business registration via a writ of mandamus. The court, however, should dismiss this mandamus action because it is not available under the facts alleged. If the City Council's decision was legislative, mandamus cannot be used to review legislative discretion. Even if it was quasi-judicial, the exclusive review method is certiorari in the Minnesota Court of Appeals, not mandamus in district court, which lacks subject matter jurisdiction. In either case, mandamus is not available. Therefore, the court should grant the city's motion to dismiss. Facts: July 28th, considered my application, ensured a full public deliberation of the topic, allowing community members to speak in opposition. Most of those community members ended up switching their opinions after speaking to me after that meeting, by the way. Funny that they don't mention that. City Manager Patrick Ian Rigg and City Attorney Joel Holst had explained they had investigated our compliance with the requirements of registration, and despite candidly presenting the possible legal and fiscal consequences of non-registration, a motion to approve the registration failed, leaving us without its requested registration. So they do readily admit that they knew what they were doing and still broke the law. Legal standard: Minnesota Rule of Civil Procedure 12.02 provides for dismissal where a district court lacks a jurisdiction over the subject matter and where a plaintiff fails to state a claim upon which relief can be granted. When deciding a motion to dismiss, courts consider questions of law de novo. When addressing questions of fact, courts consider only the facts alleged in the complaint, accepting those facts as true, and construing all reasonable inferences in favor of the non-moving party. Mandamus is not available in this case. Their first argument: the relief sought by us in this mandamus action is clear, as such writs have demanded the same relief for centuries. This ancient writ, which originated in England during the 13th century of reign of Edward II, operated as a command issuing in the king's name from the Court of King's Bench and directed to any person, corporation, or inferior court of judicature within the king's dominions, requiring them to do something particular therein specified. Mandamus ensured accountability for those in positions of authority when the legal means were lacking, which seems to be this exact situation, just saying. This writ, if awarded, would be directed to an officer of government, and its mandate to him would be, to use the words of Blackstone, to do a particular thing therein specified which appertains to his office and duty, or in the words of Lord Mansfield, the applicant in this case has the right to execute an office of public concern and is kept out of possession of that right. This view of mandamus as a tool to compel a required act affecting a personal right when the petitioner is, without any other specific and legal remedy, gained purchase in the United States because of these common law origins. In Minnesota, mandamus is now a statutory remedy. The proper procedure for the conduct of mandamus proceedings is governed entirely by Minnesota Statutes Chapter 586, which must be followed in order to effect a valid issuance of a writ of mandamus. It is elementary and well settled under Minnesota law. An action governed by statute requires strict compliance with the statute for the court to obtain and exercise jurisdiction. Mandamus is no different, and a district court lacks jurisdiction to issue a valid writ in the absence of a justiciable controversy. While the proper procedure for the conduct of mandamus proceedings is now governed entirely by statute, its sole purpose is to still enjoin the performance of a required act. This may include exercising judgment or discharging a function, but may not control the exercise of discretion, because a writ of mandamus does not control the particular manner in which a duty is to be formed and does not dictate how discretion is to be exercised. Now, we kind of touched on this in every previous video up until this point. Minnesota Stat 342.22 says shall. Shall is mandatory, meaning you don't really have discretion. So, carrying on, stated differently, mandamus is only available to compel a duty clearly required by law. As these cases indicate, a court's authority to compel municipal action varies by degree relative to the underlying decision-making process. A. Mandamus is categorically unavailable to review legislative discretion. The proceedings conducted by local government entities can result in two types of decisions. The first type of decision is legislative. Legislative decisions by local government bodies are not subject to immediate appellate review. Instead, parties wishing to challenge these decisions must first litigate the question of their validity in district court. If the City Council's July 28th proceedings resulted in legislative decision, the court would be obligated to dismiss the petition because mandamus is not appropriate to review the exercise of legislative discretion. There's a bunch of case law here. The other possibility is that the municipality's decision was quasi-judicial. Like a legislative decision, courts review quasi-judicial decisions on the record to determine if the reasons given by the city were legally sufficient and supported by factual basis. They truly, really weren't. In my opinion, the result under this possibility is the same as under the first. B. The court lacks subject matter jurisdiction to review a quasi-judicial decision subject to the Minnesota Court of Appeals' exclusive certiorari jurisdiction. Dismissal remains the necessary result even if the City Council's July 28th proceedings resulted in a quasi-judicial as opposed to legislative decision. Though a writ of mandamus may be issued to compel a quasi-judicial decision when the quasi-judicial decision-maker plainly had no discretion as to the precise manner of performance, where only one course of action was open. In my opinion, that's exactly where we are at. I met all the criteria, both in state and city laws, and therefore there was only one course of action giving me my city registration. They've essentially admitted that right there in their own memorandum to support their motion to dismiss. I could probably stop reading right here and save us all a bunch of time. But let's carry on. The Minnesota Constitution prevents a writ of mandamus here. Minnesota's constitutional mandates: the powers of government shall be divided into three distinct departments: legislative, executive, and judicial. That's duh. No person or persons belonging to or constituting one of these departments shall exercise any of the powers properly belonging to either of the others. Yes, but we do have checks and balances like at the federal level. Minnesota Constitution Article 3. This constitutional imperative limits a court's ability to review municipal decisions because, decisions of municipal bodies entail the exercise of executive powers which courts, as judicial bodies, are not constitutionally permitted to exercise. To prevent the judiciary from impermissibly exercising executive powers, the Minnesota Supreme Court has developed a body of case law and rules applicable to quasi-judicial decisions by local government bodies. The Minnesota Constitution mandates prompt, timely, and expedient judicial review of quasi-judicial decisions. The balanced separation of powers does not prohibit judicial review of municipal zoning decisions, but court authority to interfere in these matters is and shouldn't be limited and sparingly invoked. Emphasis added. Well, this does seem like one of those times. The Minnesota Supreme Court has consistently stressed the limited role of the judiciary in reviewing municipal decisions to ensure the judiciary does not encroach upon the constitutional power spheres of the other two co-equal branches of government. In Dietz versus Dodge County, for instance, the Minnesota Supreme Court recognized fundamental separation of power principles dictate certiorari as a particularly appropriate method of limiting and coordinating judicial review of quasi-judicial decisions. This holding did not result from slavish adherence to hyper-technical rules, but from long-standing recognition that when the core discretionary acts of executive bodies are challenged, the continued vitality of fundamental constitutional principles compels the judiciary to exercise limited scrutiny. Indeed, the Minnesota Constitution's balanced separation of powers generally mandates a writ of certiorari to the Minnesota Court of Appeals to review a municipality's quasi-judicial decision. Although it is an extraordinary remedy, the Minnesota Supreme Court has long held that certiorari is the remedy that allows appellate review of quasi-judicial acts. Through certiorari, constitutional guarantees are protected, and separation of powers principles dictate the continued adherence to limited review by writ of certiorari. Certiorari is only a particularly appropriate method for reviewing quasi-judicial decisions. It is, in many cases, the only mechanism by which a party can obtain judicial review of quasi-judicial decisions in the absence of a jurisdictional statute. Minnesota courts have long held that absent a right of review provided by statute or appellate rule, certiorari is the exclusive method to review the proceedings of municipal boards when the proceedings are judicial or quasi-judicial. Emphasis added. The law is now well settled. Wow, great quote there, bud. Unless a statute or other explicit bright-line authority grants a district court jurisdiction to conduct discretionary review of a municipality's quasi-judicial decision, a party's sole remedy is to appeal to the Court of Appeals by writ of certiorari, and a writ of certiorari is the only method of review available to the aggrieved party. Though this long-standing rule is well established in binding precedent, the Minnesota Court of Appeals has recently synthesized the rule: if adjudication of a claim requires inquiry into a quasi-judicial's decision's validity, then the district court is without jurisdiction. The court in Calm Waters Cannabis considered whether to issue a writ of prohibition to prevent enforcement of a district court order enjoining the Office of Cannabis Management from conducting a social equity pre-approval lottery for cannabis businesses licenses. Like a writ of mandamus, a writ of prohibition is an extraordinary remedy available only when a lower court acts without authority and no other adequate remedy exists. The petitioners who had qualified for the lottery argued the district court lacked subject matter jurisdiction because OCM's decisions denying pre-approval applications were quasi-judicial and subject to the Court of Appeals' exclusive certiorari jurisdiction. Applying the principles from Weber v. Credit River Township, the court held district courts may adjudicate claims related to agency quasi-judicial decisions where it appears that the district court can adjudicate at least some of the claims without inquiring into the validity of the quasi-judicial decisions. While some claims in the underlying action sought reversal of individual denials within the Court of Appeals' exclusive certiorari jurisdiction, other claims broadly challenged the overall process employed by OCM in implementing the cannabis licensing scheme, which are not claims unique to any individual application. The situation here is markedly different than the situation in Calm Waters Cannabis. Yeah, no shit, Sherlock. That's why I even mention it. The Smoking Trees mandamus claim requires inquiry the validity of the city's quasi-judicial decision. Calm Waters Cannabis clarifies overlap with the quasi-judicial decision, but does not defeat district court jurisdiction but the line is crossed when adjudication requires testing the decision's validity. Unlike Calm Water's cannabis, the smoking tree does not advance any claims of broadly challenging processes or procedures applicable to all registration applications. Instead, the smoking tree brings only one claim, which is unique to its individual application. Here, the smoking tree seeks a writ compelling the city to issue a cannabis retail business registration. Not only is this the only claim the smoking tree brings, this claim is a direct validity challenge, not a collateral derivative claim untethered to the merits of the city's individualized adjudication of the smoking tree's registration application. The smoking tree's mandamus claim would force the city to issue the registration, necessarily adjudicating the validity of the city's decision and invalidating it. While the situation here is markedly different than in Calm Water's, binding precedent still dictates the court decision. I mean, that's a mischaracterization of the facts. We're not forcing you or asking you to be forced to give us anything. We're asking you to follow the law. Distinct difference there, sir. Again, my opinions, I'm no lawyer, and I'm definitely not your lawyer to the viewer. But again, the state law and your own city ordinances only left one avenue, and you decide, the city here seemingly decided to act above the law and above their own city law. The situation presented here is analytically indistinguishable from the situation presented in Lund v. Minnesota State Colleges and University. Their appellant Robert Lund applied for a license to teach a machine tools careers course, which he asserted he was entitled to because he had a license to teach and was teaching metal pattern and model making, a course Lund asserted was more advanced than the one for which he sought the license. When Lund's application was denied, Lund petitioned the district court for a writ of mandamus to compel Minnesota State Colleges and Universities to either issue the requested license or to hold a contested case hearing on the licensure question. The district court, however, dismissed Lund's petition for lack of jurisdiction because Lund had adequate non-mandamus remedies, including the opportunity to seek certiorari review. It's a little different here. I would truly say it's quite a bit different here. On appeal, Lund argued MNSCU's decision was not a quasi-judicial decision subject to certiorari appeal because MNSCU's denial was not based on a prescribed standard, but on its misinterpretation of statutes and an unwritten, unpromulgated, non-existent policy. The Court of Appeals, however, made clear the question here is not whether MNSCU correctly read the statute, but whether there is a prescribed standard for making licensure decisions. Thus, because MNSCU's decision to deny Lund a license involved a prescribed standard, it was a quasi-judicial decision subject to certiorari review, and the district court lacked jurisdiction to issue a writ of mandamus. Here, as in Lund, the smoking tree argues the city failed to grant its registration application despite its having met the requirements for the registration issuance and the city having no grounds upon which to deny the application. But as in Lund, the question is not whether the city misapplied the requirements for the registration issuance, but whether there is a prescribed standard for making registration decisions. In this regard, the smoking tree does not dispute a prescribed standard for making registration decisions exist. Indeed, the smoking tree admits it is currently pursuing certiorari review of the city's decision before the Minnesota Court of Appeals. In the certiorari appeal, the Court of Appeals can affirm the city's decision, remand with instructions for further proceedings, or, as most relevant here, reverse the quasi-judicial decision and compel the city to issue the registration, i.e. exactly what the smoking tree is asking the court to do here in this mandamus action. Lund, however, confirms such decisions are reviewable and adequately remediable on certiorari. Likewise, in Silver Bay area citizens concerned for quality education versus Lake Superior School District number 381, the court reversed a decision. A district court decision. The court reversed a district court mandamus order because certiorari was the proper avenue to challenge a school board's quasi-judicial decision. The district court lacked jurisdiction, and mandamus was an inappropriate remedy in this case. The city's decision whether the smoking tree satisfied the statutory ordinance criteria for cannabis registration applies facts to legal standards to reach a binding applicant-specific outcome. Certiorari review is thus the exclusive method of review available, and the court lacks subject matter jurisdiction in this matter. Yet, even if the city's decision were legislative as opposed to quasi-judicial, mandamus remains unavailable. I don't think it's entirely unavailable. Again, we're not trying to achieve the outcome might be the same. The very end outcome might be the same, yes, of me getting a registration. With the methods of which the certiorari court would give it to us versus the mandamus one distinctly differ, in my opinion. We're not necessarily saying, hey, invalidate their decision. I would opine that we're basically saying, hey, follow the law. Follow your own law, even, in which you took away your own discretion, City Council of Albert Lea. Conclusion: for the foregoing reasons, the city respectfully requests the court grant its motion to dismiss. So there's that. To any of you who are interested, this is the next hearing date, December 29th, 2025, 8:30 a.m. This is very open to the public. You could easily obtain this information yourself from the Freeborn County Courthouse. Here is the Zoom meeting ID as well as the passcode. Feel free to join. I would ask that if you join, that you obviously be respectful. You have to mark yourself as an observer. You do not need your camera on. You do not need your mic on. You are just there to observe. Be respectful. Don't record anything. Don't, do anything that would get you held in contempt of court. You know what I mean? Don't be a dumbass. Overall, I can't expound on much of this yet due to the upcoming hearing, though hopefully this shows people that may be in my position in the future or even right now. I know there's a dozen or more other lawsuits going on that are kind of related to this. I hope this shows everyone the type of pushback they might receive from the opposing party. It's to be expected. Again, I don't entirely think the writ of mandamus / district court is the wrong avenue. I do think the precedent around the writ of mandamus is great and all, but we're also just kind of conveniently ignoring the fact, at least in this very specific instance, that the cannabis laws are so new and pretty much untested that, is relying on precedent applicable here for a brand new law? The examples given in the dismissal memorandum really aren't close enough to really sway my opinion if I looked at this in a objective and unbiased way. I could possibly see, even if the judge ruled in our favor, the city trying to appeal this. But even then, you're wasting time, money, and resources on fighting in what I would consider an uphill battle, because the statutes are so black and white, and your own city ordinances are just as black and white, to the point of, what do you aim to accomplish here? You really want to waste more taxpayers' money on fighting a bogus fight? I mean, that's not going to keep you elected. In fact, it's going to make you universally hated in your own community by your own constituents. When the young people are the ones in power, your entire legacy is going to be tarnished, your family name is going to be tarnished, and I bet people are going to just piss on your gravestone type of thing. So either be leaders of the community and be willing to explain to your community members why cannabis is a harmless thing and significantly better than tobacco, alcohol, and other prescription drugs, significantly better than sugar, caffeine, and porn, and everything else that has the potential to be habit forming, or move out of the way and resign from office and let people like me replace you, who are willing to put the work in to educate the constituents so that we're all on the same page, so that we all can have a better quality of life and have our taxes go to something beneficial to the community that builds up our community. Not this nonsense, which is just showing local business owners why they shouldn't invest in Albert Lea. I've never seen a more black and white, blatant sign to local, statewide, national investors of why they shouldn't come here. Because now every business that comes here is going to be afraid that they're going to have to sue for their God-given right to start a business. What a joke. Anyways, let's turn this back on. This is the Stay High beanie, nice ribbed knit beanie, dual colored, kind of a nice marrowed printed patch. Again, available on the Get Slicks website. Just a really nice high quality beanie for the winter that I designed and made. Outside of that, there's really not much else to say. I'd love to know what you think, and I'm sorry I can't give more info or say much more, but I can definitely give my opinions based on what is publicly available, like what I've spoken about on already. As of now, there's only one more planned video until we have to wait to get the appellate brief back from the city and have this December 29th, 8:30 a.m. Zoom hearing on the mandamus issue. Like, share, sub. I'll do my best to answer questions and help everyone else out. And I want to remind everyone, I love Albert Lea. My family's been here for over 4 generations. This is my city, baby. And I think we deserve better and we can do better. I'm not going to let a little hiccup here spoil my opinion of the city. It just makes me realize all the more that we need better people to run for positions of power, to run for office, to get rid of all these old boomer ass motherfuckers who think that they can do better and know better and act in what I believe to be a very blatantly corrupt fashion. You know, the city council unanimously passed their cannabis ordinances repeatedly, I might add, as we went over in video 1. And now, in the 11th hour, after all is said and done, after I've spent tons of money on everything, they're trying to move the goalpost. That is not right. And I think everyone can agree to that. That is wrong, objectively. Anyways, I'm going to cut it off. This has been a longer video than usual. For that, I am sorry, but I appreciate the support. Peace.